Please be seated.
Some of us, the reading is a little lighter than.
The final case for oral argument this morning is the Protestant Episcopal Church in the Diocese of South Carolina and others against the Episcopal Church and others. Mr. Hewitt, you may proceed.
Thank you, Madam Chief Justice, and may it please the Court. Most people will happily vote to avoid the consequences that they don't want. The Episcopal Church does not have a rule for everything, but it does have a plain-spoken rule about the use of parish property, and it requires a straightforward promise of loyalty from its leaders, including its bishops. If people can break these rules and vote away the consequences by changing civil documents before the Mother Church acts, that is not the freedom from secular manipulation that this Court's decisions so powerfully describe.
But there is no Mother Church according to the trial judge's formulation. It's a congregational church, isn't it?
That is what the circuit judge effectively held, Justice Placonis, and we think that is a way.
But didn't she also disallow you, and I know you weren't trial counsel, from introducing evidence that would tend to show that it is not a congregational church?
That is exactly correct, Justice Hearn. And of course, the respondents have changed their position in the present posture of this litigation because their position throughout the trial was that hierarchical structure was irrelevant. Now, in this court, they claim that the Episcopal Church is stopped from
If there is a dispute as to whether there's a hierarchical structure or congregational, who decides that dispute?
That is a dispute for the court to decide, but it is not a searching inquiry. I'm reminded of Justice Potter Stewart's famous admonition in Jacob Ellis versus Ohio, I know it when I see it.
But Mr. Hewitt, in this case, the National Church has called itself a hierarchical church. Of course, we could look at Wikipedia, but we wouldn't have to do that. We can also look at the myriad of court decisions, including one from our own Fourth Circuit, the Dixon case, which is a very thoroughgoing analysis of what constitutes a hierarchical church. And it seems by any definition, this church is hierarchical. But does that matter in this case?
Yes, that's what I want to ask Mr. Hewitt. It may have been very unbalanced to have made the rulings that were made below that allowed one side's experts and particularly one expert cited in the judge's order in aid of the congregational determination to testify very fulsomely and forbade your side's two experts from getting at all into the issue of the lens through which we should look at this dispute, hierarchical versus congregational. But in the final analysis, specifically with reference to the property determination, the title determination, what difference does it make?
It makes a difference because you have to know what sort of animal you're wrestling. I would direct you to the Parish of the Advent case and the Diocese of Massachusetts versus Divine case, both out of the state of Massachusetts, that say, even though we're following neutral principles, we begin by acknowledging that the church involved, the Episcopal Church, is a hierarchical church.
Well,
and we do that.
Assume that's the case.
Say it's hierarchical. Say we make that determination just as Justice Beatty has posited.
Not yet.
When we look at the titles, what do we see?
Well, title is not contested in this case, and that is an important distinction I want to make. Nobody contests that the parishes have title.
Your argument it is the Dennis Canon imposed an express trust on this property, and for 30 years,
That's what I was going to posit.
That's exactly correct.
And as you point out in your brief, you argue that we should plug in this doctrinal or administrative or canonical determination prior and accept it and then apply neutral principles. Is that pretty much it?
That's correct. There are a couple of doctrinal matters or matters of polity that I think the court was required to plug in. And one of those that's very important, which was excluded by the circuit court, in our view erroneously, is the decision by the presiding bishop of the Episcopal Church and the decision by the House of Bishops in the Episcopal Church to depose the bishops who tried to lead their diocese out. I'm referring to Bishop Schofield in the Diocese of San Joaquin and Bishop Duncan in the Diocese of Pittsburgh.
But of course, in this case, Judge Goodstein wouldn't even let Counsel for the National Church bring in what had been done as far as disciplining Bishop Lawrence. In fact, she threatened to revoke his pro hoc vici statute if he didn't stop talking about that. Isn't
That is
correct?
exactly correct. And the basis of her ruling that this evidence was inadmissible was that South Carolina is, quote, not a hierarchical state.
Well, she seemed to think the two principles, hierarchical and neutral principles, can't coexist. But there's lots of cases that say they can. What's your position on that?
I agree with the latter formulation that you articulated completely. Neutral principles. I'm sorry?
That's a tremendous surprise there, Mr. Hughes.
I am picking up your shock, Justice
Mr.
McInnes.
Yu, who owned the property the day before the Dennis Canon in 1979?
The Episcopal Church has never claimed that it owned the property. The parish owned the property.
Well, and in All Saints,
Well,
he
last
said,
question, who owned the property the day before the Dennis Canon, which you say is the greatest thing ever and wins the case for you? Who owned it the day before?
The parish owned it, but under Watson versus Jones, it was held in trust for the Episcopal Church, because before Jones versus Wolf,
Does that mean the parish or does that mean the national?
the parish owns it. The trust restricts how property can be used. It's no different than the way trusts operate in civil trusts.
well, what about what we said in All Saints? In All Saints, we said about the Dennis Canon and the attempt to use the Dennis Canon, just as you are wanting to use it, to create an express trust on behalf, I suppose, of both the diocese and the national church. You don't just confine it to the diocese. You say it's an express trust on behalf of the national church over this undeniably parishionally titled property. We said that in South Carolina, creating an express trust cannot be done unless the set law, that is the owner of the property, creates it. Now, how did those parishes, as set laws, create a trust in the national church?
Because they participated in the form of government that led to the acknowledgement and codification of that trust.
And Mr. Hewitt, doesn't this call into question the teaching of Jones v. Wolfe about what is necessary for a national church to be able to create a trust? And that burden is supposed to be minimal.
It absolutely does, Justice Hernan. If the passage you're referring to, Madam Chief Justice, in All Saints means exactly what it says, which that's what the respondents say. They say denominational trusts in a constitution are of no effect in South Carolina. Then Jones versus Wolfe does not mean what it says, because Jones says there are a variety of ways.
Well, walk me through specifically how this got created. The national church in 79 propounded the Dennis Canon, and this Dennis Canon said that any Episcopal church is holding its property in trust for the national church. And the national church said that.
And its diocese thereof.
And then what happened? How did the set law, by any kind of express acknowledgement, say, yes, we are holding this property in trust for the national church?
29 of them did so expressly, as detailed from pages 101 to 106 of the Record on Appeal, by publicly acknowledging their accession to the Constitution and canons of the Protestant Episcopal Church of the United States of America after the Dennis Canon's enactment.
And isn't it correct that this particular diocese enacted its own version of the Dennis Canon?
It is. In point of fact, this diocese had a Dennis Canon before there was a Dennis Canon. This diocese had a Dennis Canon before 1979, Justice Kittredge, since at least 1969. That's page 1839 to 1840 of the record. So,
And Mr. Hewitt, I want you to, I'm not disregarding the number of cases that have reached the result you are arguing for with regard to the Dennis Canon, and in almost all those cases, cert has been denied or dismissed by the U.S. Supreme Court. But I would like you, or I'd like to hear you, about the Masterson case out of Texas, which seems to take more of an All Saints view. I will note that our sister state of Georgia, in a 2011 opinion, noted that the South Carolina decision in All Saints has not been followed in a church property case by any court outside that case, outside that state. So we're dealing with a bit of an outlier, if you will. But tell me about Masterson.
sure, and if I can just touch on the second part first, that is still correct. I checked yesterday. All Saints has only been cited 8 times outside of this state and never followed. Masterson tells us that the state of Texas is an open question. We don't know yet whether the state of Texas will enforce the efficacy of the Dennis Canon. The argument in Masterson was that Texas follows deference, not neutral principles.
Can this case be distinguished from All Saints? And if so, how?
Yes, Justice Placonis. With respect to the Dennis Canon, because of the evidence of accession, 29 of the 36 parish respondents publicly acknowledged their accession to the Dennis Canon after its enactment. The remaining 7 are bound by their previous accession. We would direct you to the Goss case out of Connecticut, which says the Dennis Canon imposes an express trust when the trust provision from 1979 is combined with previous accession.
Now, I was just going to ask you, Mr. Hewitt, I did not sit on the All Saints case, so I am not privy to that record, but cited in the All Saints case is the existence of a 1903 quitclaim deed from the National Church, as I understand it, to the parish, to the All Saints parish. Does that have any play in differentiating All Saints from this situation?
It is certainly a...
Well, it was a quitclaim from the diocese.
That's right, and it's an important factual distinction because that quitclaim deed served a purpose in All Saints. Under an 1882 statute, all vacant parish property had reverted to the diocese.
What about all the quitclaims that were issued here?
Well, that's the interesting thing, Justice Hearn. In this record, you have clear representations from the diocese and its representatives that they didn't think they were giving anything. They gave quitclaim deeds to the parishes, but then they filed this document in the record, page 113, that says, for 190 years, there's never been any question that the parishes didn't fully own their property, which of course we don't contest. And that's just not true. We know that before Jones versus Wolf, there was no question that hierarchical churches had a trust interest, a beneficial interest in the property.
And if indeed these parishes held the property in trust, then the efficacy of a quitclaim deed from the parishes, from these folks, had no efficacy at all, did it? Because they would have then breached their trust.
That's right, Justice Placonis. I mean, the quitclaim deeds in this case represent part of an attempt to drive this case.
Wait a minute. The trust is a trust created by the set law, and the set law is the parish that owns the property. And the diocese, under the Dennis Canon argument, because the National Church passed the Dennis Canon, and the diocese also adopted the Dennis Canon and its own version of it beforehand, that this express trust is that somehow because the local churches have acceded to be members of the diocese and the national church, they have created as set laws, an express trust for the benefit of the diocese and the national church. Now, if the diocese, as the beneficiary of the trust, there's no violation of the trust by the diocese as the beneficiary transferring their interest back to the set law. In fact, sometimes the statute of uses, as it did in All Saints, does that for you. If there are no trust, if there are no other folks around to do that. But that wouldn't be a violation of the trust if the beneficiary says, I'm going to reject my beneficial interest in this property and transfer it back to the settlor. And in that case, the settlor's title and the trust would merge, and you would have title wholly in the settlor, correct?
That's true, Madam Chief Justice, but 2 points on that. The first is that the diocese testified in this record that they didn't think they were doing that. They saw these quitclaim deeds as accomplishing nothing. When asked whether these quitclaim deeds gave any interest to the parish,
we don't
they said,
generally,
well,
when we look at deeds, we look at the deeds and what they say on their four corners. We don't look at why they did it or anything else. And what you have here, you're arguing in one argument an ultra vires argument. That is, whether this particular bishop had the corporate authority to do what was done, and I'm going to be very interested to hear about that, because the motivations are not lovely. They are unlovely, no question about that.
Can I stop you there briefly?
And you all were not permitted to get into exactly what was promised by the bishop to get his job as bishop and to be put in that legal position as corporate head to be able to give these quitclaim deeds.
That's right. He couldn't do it without.
Well, but on the issue of whether these quitclaim deeds are valid or not, the motivation means nothing. Authority, though, corporate authority means anything, and if there's something imperfect about the corporate authority of this particular individual, that's a problem. And what I want to hear you on is what is imperfect about his authority, because what the national church did is also very confusing and unlovely. They knew this individual was interested in leading these people out of the church, and that's why the national church didn't confirm him as bishop the first time he was elected by the diocese. Later on, he made, and there are a lot of weasel words used here that just astound me in this record, promise, vow, oath, declaration. It all was the same to me, a written promise that he would remain faithful to the national church. But you let him do that, and you gave him the authority, the national church did, to be vested with the corporate authority as head of the diocese. And you did not discipline him or take his authority away in any way. So he sailed right on through and made this quitclaim deed. How can we go behind this?
Well,
unless
of course,
you can...
Mr. Hewitt, if we're going to talk about that, I would like you to talk about his vows and how the national church assumed he would be true to his vows, especially when he wrote a letter saying, I intend to stay with the national church, period.
Well, I'm
too.
agreeing with you, Justice Hearn, and that's what I'm warning is the absence of the ability to explore that the foundation of your contention that this was an ultra vires act, but you weren't permitted to get that into the evidence?
I don't think we need more evidence to demonstrate that Bishop Lawrence had absolutely no authority to give away the national church's beneficial interest in parish property. He was not invested with the authority to do that. And the suggestion that the national church knew he was going to lead the diocese out, I'm sure offends my client, and I think is probably highly offensive to the national church.
Well, why wasn't he approved the first time? He was
because a majority of the standing committees in other dioceses refused to consent to his ordination, and he was only approved after he wrote a letter saying, I will take the vow of conformity, that I will conform to the doctrine, discipline, and worship of this church. And I'm going to tell you why it's important. You can look, Jones versus Wolf tells us it's important to look at the parties' understandings before a dispute arose. And there are several different dates you could use here. You could use 2013 when the case is filed. You could use 2012 when these corporate actions are taken. But I'm going to direct you to April 18th, 2009, which is when Bishop Lawrence signs a statement, a so-called statement of polity by 15 bishops of the Episcopal Church that says a bishop is the supreme authority in the diocese. This is not a hierarchical church. If we want to put our flag in the ground and leave, we can do it. Why is that significant? Because it shows that less than a year after he takes his vows, he had his fingers crossed behind his back, and it's before All Saints is even issued. All Saints is not issued until later in 2009.
Might that explain one reason All Saints was not sought?
Well, the case, all we know is that the case was settled during the U.S. Supreme Court cert process. Nothing else is in the record on that. We feel quite strongly about our corporate control argument, Madam Chief Justice, as we do our other neutral principles arguments. And I think one of the beneficial things about this case
What
is
is in the record that supports your argument that the Bishop Lawrence lacked corporate authority when he executed those quitclaim deeds?
he could not, because of his ordination oath, he could not take acts that are inconsistent with the doctrine, discipline, and worship of the Protestant Episcopal Church. And the General Convention had already defrocked the two bishops who put the thoughts he articulated in that April paper into practice. That happened in 2008.
Had they defrocked him?
They had not, because he didn't put those views, as I say, into practice. Now, as soon as he did, as soon as they...
Well, he said he was. He in as good as put them in practice, because he said he wasn't going to follow the dictates of the national church, that the bishop was going to be the supreme authority. And at that point, he had not issued the quitclaim deeds, had he?
The record does not show that he made that claim publicly to the national church. That was not an argument that was articulated before the circuit court. I mean, I'm just focusing on that date because it appears on the document that is in the record that was offered in support of their view that the church is not hierarchical, which as you articulate, I'm sorry, I see my time has expired.
No, you go right ahead.
As you articulate so correctly, Justice Hearn, there are legion of decisions recognizing that the church is hierarchical and virtually no decisions, as the Fourth Circuit articulated in Dixon, to the contrary.
If this diocese is truly congregational and can just pick up its toys and leave whenever it wants to, why did it then become part of another larger group? Did it not, after it purported to leave the national church?
The Rwandan?
That was certainly the case in All Saints. I don't know that the record bears that out here.
There sure is a lot in the record, and I thought there was some discussion that they were part of another larger group. And so my question was, if they really were a congregational entity, why?
I thought they associated themselves with the North American Anglican Church or some such national. They have associated themselves with some larger group than the Diocese of
I
Charles.
thought it was Global South, a group of third world, mostly provinces in Africa. I could be wrong.
I think the spirit of your question is very germane, Justice Hearn. I mean, I'm hesitant to answer because I don't know that fact appears in the record. A decision out of the state of Virginia, the Truro Church case, describes in its factual background sort of the global nature of it.
Why isn't this a case? I'm going to ask the same question to opposing counsel. Why isn't this case boiled down to its essence, just a question of who should lead this diocese? Who is the rightful bishop? And hasn't the national church answered that question by ordaining Charles von Rosenberg?
That was our central argument at trial. We agree completely with that articulation. Disputes about leadership are not like property disputes. Jones versus Wolf is principally a property dispute. Disputes about leadership, as many cases articulate, the Parish of the Advent case, the Divine case, the dissent in Banks versus St. Matthew Baptist Church, says disputes about leadership are different. They evoke the authority to lead the church and the ability to speak for the church, invoke the church's authority. That's exactly correct, Justice Hearn.
Madam Chief, may I ask a question? No time's expired. Summarize what relief you seek. What would be in the order of this court if you wrote the order?
I would direct, are you talking about the disposition or?
The disposition of this case.
The conclusion section in our principal brief and our reply brief, which says that the diocesan corporation belongs to the true diocese, which is us, the client that I represent. Parish property is held in trust for the national church and its true diocese, which is us. The trademarks that they claim sued us for infringement over, the state trademarks, that is not a valid infringement claim because those marks infringe with our federal trademark.
So as you say, you want the court to declare that your client is the true diocese.
I do not want the court to declare that. I want the court to recognize that the General Convention of the Episcopal Church has declared that my client is the true diocese. And I don't think that conclusion is debatable. For this and the reasons
and that does not affect title to the property.
That does not
trust.
That does not affect title either to parish property or the diocesan property, which we have not discussed in the course of this argument, but which is controlled by and large by a statute which was enacted in 1880 and by common law principles of trust law which this court articulated in Department of Mental Health versus McMaster.
Well, now, the title to the diocesan property, the St. Christopher's Camp, etc., that is titled in the trustees of the Episcopal Church. This is a separate corporation from the corporation that is called the Diocese, the Protestant Episcopal Diocese, right?
Right, and we do not contest that title is held in the way you described.
And so if title is held, if St. Christopher's is held in title by these trustees, are these trustees bound to the so-called true diocese in the national church?
They are because of the language of that statute and because of common law principles of trust law, which this court recognized in DMH versus McMaster. And I'm happy to walk through that if you would like, but I don't want this to be an exercise in tedium.
Let me ask you one more question before we turn to the other side. It's about the service marks. We've got state law on service marks, and then we've got the Lanham Act and federal law. And I see where yesterday Judge Houck decided to lateral the ball back to us on the Lanham Act.
I know you were pleased.
Oh, very much so. But I will tell you that's not going to control whether we lateral it back to them by saying that's a federal question and they got a suit up there and they need to go on and decide it. But what are we supposed to do with that issue now, the Lanham Act issue? Are we supposed to decide it down here in your view?
We can, can't we?
The only issue that is in front of you with respect to trademarks is our argument that neutral law does not allow confusion with federally protected trademarks, which we own and whose validity has not been attacked. So that is the only issue with respect to trademarks that is in front of you. Now, they would tell you that this is not an infringement case, that they weren't sued for infringement, which is not true, but we'll come to that in just a second. The problem is they sued us for infringement, and they can't establish a prima facie case if their state trademarks infringe on our federal trademarks. The way you know that we did sue them for infringement, which you don't have to reach, is that 13 of them have filed a lawsuit in federal court against the church's insurance company and filed an amended complaint in July when they said, we were sued in state court for trademark infringement. So if you can reconcile those different narratives, you're smarter than I am. For the reasons we articulated, both here and in our brief, we ask you to reverse. Thank you.
Thank you, Mr. Hewitt.
May it please the Court, Madam Chief Justice, Justices, I want to try and focus on what I think, what I have heard that suggests that All Saints does not apply here. There really is no legal or factual distinction between All Saints and the facts of this case. And the reason that is the case is because you had a bishop there who declared that the loyal officers were the ones in the minority. And in spite of that decision, and in spite of the issues of corporate identity and whether it was a parish in the Episcopal Church, this court looked at that issue and decided instead, under neutral principles of South Carolina law, it didn't matter if it was a hierarchy. It didn't matter if the bishop had done that. All that mattered is, did this organization, All Saints Parish, who had been with the diocese for a long time and who had pledged conformity to their rules and regulations, modified their corporate purposes charter using the same language that we had in ours. They operated under the Protestant Episcopal Church rules, and ours said the same thing about the national church. Both were modified under the neutral principles law in South Carolina, and that really should be the end of the matter under neutral principles of law.
I have two questions for you about that, Mr. Runyon. The first one would be the language in the All Saints opinion that talks about where a civil court has presented an issue which is really a question of religious law but is masquerading as a property dispute. And I know you're familiar with that language. So why isn't this that type of situation? But my second question, and I'm sure you'll address it, there has been a motion to argue against precedent. There's a different court here. Of course, we take precedent very seriously. But the majority of this court did not sit on the All Saints case, and you would have to acknowledge it is an outlier in this country. So if you could address those two issues for me. I understand why you want to argue All Saints. I would too if I was in your position, but if you could answer that for me.
Well, the reference in All Saints to Masquerade had to do with the Serbian case. The Serbian case involved a situation where the bishop controlled the property. It's undisputed on this record that the Bishop of South Carolina does not control the property of the Diocese of South Carolina. That property is controlled by the corporate entity, the diocese. The diocese is controlled by its convention and by its standing committee. The bishop is a corporate officer. He has no special effect on title to property just because he's the bishop. He is a voting member in the convention, just like everybody else is. He's not even a member of the standing committee. He's ex officio.
Recall, Mr. Runyon, that in All Saints, there wasn't any dispute about the bishop's control of at least some potential interest in All Saints property. There had been the legislation in the 1880s. This was very old title. No trustees after the two initial ones, questions of the operation of the statute of uses, questions of whether the title reverted to the diocese, which was in existence way long ago as a subdivision of state government, as well as the diocese of the state ordained church. So we had a very different situation there, and into that mix comes the All Saints people in the 1900s, early 1900s, wanting to renovate the church, and the diocese with no money or no desire to go on the note. And so the diocese said, if there's some question of your being able to borrow money, we'll solve that. Our bishop will quitclaim any interest this diocese may have because of reversion of title or any other, or legislation or any otherwise, to the local church. And the local church will then be in complete fee simple possession of title and able to go out and borrow money. No question about the bishop's authority. Serbian church, no question about the bishop's authority. Here, big question about the bishop's authority in light of not only what's been argued about what the other side was not able to get into about the effect of the bishop's activities in obtaining his bishopric by making a promise, vow, declaration, or whatever you want to call it, to the national church, but also big questions about whether the diocese, whether the bishop has any ownership interest at all to deal with because of Dennis Canon. So big difference between this case and All Saints, where there wasn't any question about the bishop's ability to quitclaim. Would you agree?
I would approach it a different way, Your Honor. In All Saints, the quitclaim actually came from the trustees on behalf of the diocese. I think the question is, was that a deed for the bishop or was that a deed for the diocese, and where was the authority there? There isn't anything to suggest that the bishop had the corporate authority on his own to execute or have executed a quitclaim deed. It didn't happen that way in All Saints. It didn't happen that way here. The quitclaim deed, the bishop's actions here are as an officer of the corporation. He also happens to be a bishop. But
officer of which corporation?
Of the Protestant Episcopal Church in the Diocese of South Carolina. And
I thought all y'all's property was owned, to the extent you own any property, by the trustees, a separate corporation.
It is, and he's also an officer of that corporation.
Was the quitclaim on behalf of both?
The quitclaim deed in this case was on behalf of the Protestant Episcopal Church in the Diocese of South Carolina.
And the trustees were not mentioned as a quitclaimor, were they?
That's correct. They were not. To get to Justice Hearn's second question, if I could, the problem this court is faced with, if it should choose to follow a deference approach.
The majority rule? on the Dennis Can?
No, I don't think, well,
Well, there are about
They-
8 or 9 at least.
there
maybe 10.
are a lot of state cases where the issues have been undisputed and where the court has ruled that way.
And I recognize
and
there are
there-
different nuances to each of those cases.
There's no question about that. But the law of South Carolina on the Dennis Canon is very clear. Has a trust been created by
Are
the
you
Sept
talking
Lord?
about all saints when you say that,
Talking
that the
about-
law is clear?
I'm talking about All Saints, and I'm talking about this
Well,
case as
let's
well.
look at All Saints. There was no analysis in All Saints of the myriad of cases that go the other way. There was no mention of that. How do we know what was really presented in All Saints?
Because it doesn't really matter. The question is, what is the law of South Carolina on express trust? That's the question. And the answer to that question is the declarant, the creator of the trust, the settlor, has to declare an intent to give that property in trust to someone else.
You would say that the only way there could have been a trust created is if the national church got each individual parish to agree?
That is what the United States Supreme Court said.
But how would that be the minimal burden that Jones v. Wolfe says they're placing on national churches to do this very thing?
First of all, the U.S. Supreme Court doesn't say that, and I'll get to that in a second.
Well,
Secondly,
talk about that.
Secondly, the burden issue was never presented to the trial court. It's not been raised until we got the appeal. So, but leaving that aside, the U.S. Supreme Court gives two basic ways prior to its statement about minimal burden. It says, national church, you can alter the deeds to put a reversionary clause in it, or you can put a trust in the Constitution of the national church if it is legally cognizable.
All
It
right.
did not create a federal law of trusts. So under the law of South Carolina, it requires a declaration, and it requires that it be executed.
Well, let me ask you about that.
And it requires that it be clear
Let's
in
stop
favor
there just a
of the
minute.
trust.
Jones v. Wolfe was decided in 1979, coincidentally the very same year that the General Convention adopted the Dennis Canon, and I believe your client had a seat, had representatives there. The Dennis Canon was in effect here for about 30 years till this brouhaha happened, and in fact the diocese adopted its own version of the Dennis Canon. But what I want to direct your attention to is, what about Section 3331-180 of our Nonprofit Corporation Act that says if religious doctrine governing the affairs of a religious corporation is inconsistent with the provisions of this chapter on the same subject, the religious doctrine controls.
Well,
I mean, why isn't that South Carolina General Assembly saying something like the Dennis Canon would trump any suggestion of state law?
excuse me, I'll try to get to all of those questions.
I know I loaded you up.
The very first answer to that question is, all that statute says is that the Constitution of the United States and the Constitution of South Carolina trump that series of statutes where that's required to take place, because otherwise it would be unconstitutional, and it sets up religious doctrine as the issue. The Dennis Canon is not religious doctrine. It's purportedly declaring an interest in property.
It's a governance measure, though, is it not?
It's an attempt to create an interest in property that's contained in the Constitution and canons of the Episcopal Church, which I might add the parishes are not members of, and that's admitted in this record. The parishes didn't have a chance to vote on that. To the extent they had a chance to vote on anything, it was in the diocese Constitution and canons, and the diocese took that out. It had been
Exactly.
out.
Now, there you go. Let's say that the Dennis Canon had some effectuating creation of a trust. The trust was for the benefit, as I understand the Dennis Canon, of the Episcopal Diocese and the national church. That's what the Dennis Canon created, was a trust over the parish property for the benefit of the Episcopal Diocese and the national church. The Episcopal Diocese that you represent disclaimed its trust interest as a beneficiary and gave it back to the settlor, if in fact the parish was the settlor, correct?
Correct. Plus, it also removed the operative provision from its.
It also removed the Dennis Canon from its doctrines and removed its adherent. And it also unjoined the national church, correct?
Correct.
Withdrew its accession, I think is maybe the way to describe it.
That's correct.
Now, is there anything that prohibits that? I mean, is these accessions, once you accede to a diocese and the diocese accedes to the national church, is that forever?
No, Your Honor, and it's not just by looking at the term itself. Accession isn't a term of religious fealty. It's just an expression of contract formation.
If it didn't mean anything, why was one of the first things that your clients did was remove that language?
Because we no longer consented, we no longer agreed with what we had previously consented to. Accession just means agree to. Accession is an expression of we agree with this document, just like the Parish of All Saints agreed to conform, an agreement to conform to those documents. If accession meant that you could never remove it, that would make this contract irrevocable in the face of silence.
And
that would make it a...
You think you can do that as the settlor under our state law?
I think as one of the parties to the associational contract between the diocese and the national church, just like between All Saints and the diocese, yes, you can remove
Perhaps it's an inartful question. I'm just wondering if, does your analysis there, is it impacted if we determine that this is a hierarchical church? Could your clients unilaterally take the steps they took if it's determined to be a hierarchical church?
Yes, because hierarchy doesn't matter, and I'll tell you why. Hierarchy is completely irrelevant to the resolution of this case for a couple of simple reasons. Number one, we are not a unitary body. The Episcopal Church is not unitary.
Now, that is something that disturbs me, Mr. Runyon, because this case was tried in a rather one-sided way on that particular issue. You all were allowed to put in an expert to discuss in detail his opinions about whether hierarchical matters because of the peculiar way in which he thinks the Episcopal Church is set up nationally and in diocese. Now, the other side had Dr. Walter Edgar and Professor Martin McWilliams for two that were prepared to delve into specifically matters of hierarchy and so forth. And they were completely stopped from arguing that, from presenting evidence about that, and then, because the judge said that we're not going to make a finding about hierarchical versus congregational or anything about the nature of this particular church if it's hierarchical. And then the order comes out and it finds that this church is a congregational church. How did all that happen with the way this case was tried?
Yes, Mr. Runyon, and I would point out, echoing the Chief's concern, this was a non-jury trial, and yet I counted over 25 objections to Professor McWilliams' testimony in a non-jury trial. You all tried so hard to keep any of that evidence out, and then the order is issued, and lo and behold, there's a finding that this church is controlled by the bottom, that the parishes are really in charge rather than the national church. So
Your Honor,
help us with that.
The way that happened is that the Diocese of South Carolina and the parishes put in their case in chief strictly evidence on the votes, compliance with the Nonprofit Act in order to sever their relationship. That was the way it happened. And then the Episcopal Church began to put in specific instances of control by citing to the Constitution and canons about how they nevertheless had some implicit right to control the diocese and keep it.
They argued that, but they were not permitted to put in any evidence on that point. That's what the reason I'm asking the question. And the judge said, I'm not getting into that. She termed it, we aren't a hierarchical state. It's a kind of an odd thing because we've discussed both those principles in All Saints. But she said, none of this information is going to be considered by me because we are neutral principles. How in the world, if that is the framework that was used, was a finding made specifically that this is a congregational, that the Episcopal Church is a congregational church?
Your Honor, I know that it surely does read that way.
That's exactly what it said.
But what I think the court was doing was dealing with the concept that under neutral principles law, when individuals voluntarily join an association, it comes with the implied obligations that go along with that joinder. And the Episcopal Church...
Well, there was a whole different idea. There's a different side to that and a different set of arguments is the reason I'm asking those questions. It may have nothing to do with what we ultimately decide because property law may trump all of this. But in terms of you're now getting into this hierarchical congregational dispute and trying to use the perceived status of the Episcopal Church as a congregational church, when your own expert explicated in detail the apostolic succession of your bishops, beginning with the apostles, and yet this judge finds that it's a congregational church, I'm struggling with that as a means for justifying this order.
I'm not trying to get into that, Your Honor. I was trying to answer Justice Kittredge's question about if it was a hierarchy, would it make a difference? And the answer to that question is no. And the reason it's no is because this court has recognized in its hierarchical decisions that preceded All Saints that there must be a decision from the correct body
Pearson versus the Church of God.
On the issue in question. And the United States Supreme Court has said unambiguously that you cannot search for that body. It must be unambiguously clear in the documents between the parties that authority has been given to a particular entity within the hierarchy to make those kinds of decisions. And on this record, there is no proof of that.
Doesn't that just get us back to our different interpretations of what the Dennis Canon really means and does?
This is not a Dennis Canon issue. This is a corporate control issue that has to do with whether the diocese can legally withdraw from the Episcopal Church. Once it withdraws from the Episcopal Church, and indeed I would contain, since it's its own body before that, this court can't pick between the two. That's an Establishment Clause violation.
Because the National Church has already chosen, has it not?
No.
The National Church has chosen von Rosenberg as the bishop.
Why
doesn't that end it? I wanted to ask you that question. I said I was going to.
Because there are two organizations here, not one. And for this court to say that Bishop Lawrence is or is not the bishop of the diocese, or Bishop von Rosenberg is or is not, is to ignore. May I finish?
With why we wouldn't defer to the National Church's decision on that obviously ecclesiastical matter. You say in your brief, in the red brief, you say, of course, civil courts could not decide who was the appropriate minister. Well, but it seems like you're doing exactly the same thing here. You are saying the court can decide who is the rightful bishop. So help me with that.
Because you have made the decision by doing that, the diocese did not and could not withdraw. By
You're
doing
getting back
that,
to All Saints again.
You have made that civil decision, which is the establishment of their church against the freedom of religion that we're entitled to exercise. And the United States Constitution, as interpreted by Serbian, as interpreted by Hull, as interpreted by Maryland and Virginia and Jones v. Wolf, says you cannot do that. You cannot do that.
The thought posited by Justice Hearn, if I'm correctly interpreting it, would have nothing to do with an individual parishioner choosing to leave the body of the church. And is there a difference? Certainly the church, nobody could prevent an individual parishioner from leaving a church. I agree with that completely. But is there a difference here when en masse the group decides that they're going to have a different governing body in effect?
Individuals and associations are accorded the same rights to freedom of association, of assembly, and association. Disabato, this court's opinion written by Justice Hearn, I believe, applied that to an association in that case. So the diocese, as an association, as a group of people, has the same rights to freedom of association, including the right not to
Mr. Runyon,
associate.
I don't see any argument or hear any argument from the other side that your clients have a perfect right, an absolute right to disassociate, to leave.
But that's the
problem
entity.
is, can they take property that arguably has been held in trust for the national church for decades with them?
The question is, who controls a corporation? Because corporate control is the decision that decides who the leaders are and who owns the property.
Exactly, and particularly after the nonprofit acts were changed, all these organizations started to file articles of incorporation with the Secretary of State, including this diocese. And there's nothing in those articles that are filed that forbids the corporation that we're talking about, which is your client, from disassociating or de-accessioning from the national church. Their corporation, they legally changed their purpose. They withdrew their accession to the national church, and as a corporation, they had the authority to do that. That's your argument.
That is my argument, Your Honor, and that is consistent
If we
with
look
all
at it
saints.
strictly as a matter of corporation law, and don't get tangled up in all the doctrinal issues, as a matter of corporate law, they legitimately filed papers accomplishing that. That's your argument?
Yes, Your Honor.
Then let me ask you this question. Isn't it correct that at the time of incorporation, the stated purpose of the diocese was to follow the doctrine and polity of the Episcopal Church?
To continue to operate under
Yes,
the Constitution.
that's the language I was looking
That's
for.
it, yes.
Yes.
Yeah, that is correct.
Was that meaningless?
No, those were operating rules. They chose to operate under them, and they chose to remove them.
And
which
they can
had
change their
They had
mind.
of course they can change their mind. Thank you, Your Honor.
Mr. Hewitt, in reply?
Thank you, Madam Chief Justice. May it please the Court. Justice Hearn, you have correctly zeroed in on the language from the Charter, which we think is absolutely meaningful, and we would direct the Court's attention to this Court's precedent in Harmon v. Dreer, which has been called one of the first neutral principles cases, which precedes Jones v. Wolfe by over 100 years. And in Harmon, this Court spoke powerfully and said, the truth is that liberty is infringed. We're not establishing our religion is against theirs. We're not telling them their religion is afforded second-class status. The truth is that liberty is infringed when contracts are violated, that these words in a corporation's charter have meaning and are binding.
But Mr. Hewitt, there is nothing in the corporation law of this state that forbids a corporation, if it does it correctly and according to the law, from changing its purpose, is there?
Not according to the expert testimony we offered at trial, which is that a corporation may not amend its articles in a way that conflicts with its articles.
So once let me see if I get you. You want us to declare that the corporate law of South Carolina is that once you put a purpose clause in your charitable corporation, you are forever bound to that purpose clause, and it can never be changed, even if your Constitution and other operational documents are properly amended to do so.
Well, if they're properly amended, you got no problem with it. What you're saying is it's got to be amended in accordance with the rules regarding amendment.
That's correct. I mean, this is an attempt to distinguish between a religious organization's civil corporation and the religious body itself.
What constitutional documents were violated by amending the purpose to withdraw their accession from the national church?
The provisions of the national churches, Constitution and canons, which...
And you're saying that the national church, once you join it, you can never unjoin it. unless the national church lets you unjoin it.
That-
All right, what principle governs that? The Dennis Canon?
No, Madam Chief Justice. I mean, the General Convention has spoken on that. The General Convention has found, by disciplining the bishops who tried to lead their diocese out, that a diocese may not unilaterally leave the church.
Well,
Speaking of the diocese's relationship with the national church, talk to us about in 1922 when there was only one diocese in South Carolina and they wanted to divide into two. Did they do it on their own?
They did not. They sought the permission of the General Convention. And Madam Chief Justice, I understand, I believe, the spirit of the questions that you are propounding, but I would be remiss if I did not say that I strongly believe that corporate control, a dispute about corporate control and leadership, is not a property issue and is not appropriate for neutral principles. We have given you ways in the brief to distinguish All Saints. All Saints is readily distinguishable based on several facts. There's no trademark issue there. There's no argument about the parish's accession to the Dennis Canon. There's no argument about diocesan property. But candor requires me to tell you that I disagree with the premise that a church's civil identity is separate from its religious identity in terms of affiliation with the church. There's no way to determine church membership that doesn't conflict with the Constitution. And if you are resolute in your view that All Saints controls in the way that they say it controls, I strongly encourage you to consider overruling Harmon versus Dreer, overruling Selden versus Singletary, which is 6 years after Jones versus Wolfe, which is strongly in my client's favor, overruling Dickey versus Atkins, overruling all of the South Carolina cases that we believe support a result in favor of our clients. As a lawyer who tries to distinguish a coherent rule from this court's precedents, it is difficult to lay those precedents on the table and read them as saying the same thing. We have not discussed a lot of the neutral principles issues, the trademark issue in detail, the statutory construction issue in detail, the corporate control issue in exacting detail, but I would direct you to our briefs, which we believe articulate the correct arguments, and we would ask you to reverse. Thank you.
thank you, Mr. Hewitt. Court will be in recess.